by Justice Kagan where exceptions to that rule were read in. Given that history, regardless of how we define jurisdictional statutes versus claim processing statutes in recent times, isn't the fairer statement that Congress has accepted that in the extraordinary case we will hear the case?
No, Justice Sotomayor, because in many of these amendments, which have come in the 70s and the 90s and the 2000s, the Congress has actually framed the limited exceptions to the Anti-Injunction Act in jurisdictional terms. And it's written many of the express exceptions by saying, notwithstanding Section 7421.
But doesn't that just prove that it knows that the court will impose a claim processing rule in many circumstances, and so in those in which it specifically doesn't want the court to, it has to be clearer?
Well, but Congress says, notwithstanding 7421, the court shall have jurisdiction to restrain the assessment and collection of taxes.
Would you go back to the question that Justice Alito asked? Assuming we find that this is not jurisdictional, what's the parade of horribles that you see occurring if we call this a mandatory claim processing rule? What kinds of cases do you imagine that courts will reach?
Right. Well, first of all, I think you'd be saying that for the refund statute as well as for the Anti-Injunction Act, which has very similar wording. So if the Anti-Injunction Act is not jurisdictional, I think that's also going to apply to the refund statute, the statute that says you have to first ask for a refund and file, within certain time. So it would be both of those statutes, and we are dealing with taxes here. If people can
that
litigate.
Wasn't my question. My question was, if we deem this a mandatory claim processing rule,
right,
what cases do you imagine courts will reach, on what grounds, assuming the government does its job and comes in and raises the AIA as an immediate defense?
Well,
where can a court then reach the question despite?
That would certainly be the first class of cases that occurs to me, where if the government does not raise it in a timely way, it could be waived. I would think plaintiffs would see if there was some clever way they could get a suit going that wouldn't immediately be apparent that it
assumes the lack of competency of the government, which I don't, but what other types of cases?
Mr. Long, I don't think you're going to come up with any, but I think your response is you could say that about any jurisdictional rule. If it's not jurisdictional, what's going to happen is you're going to have an intelligent federal court deciding whether you're going to make an exception. And there will be no parade of horribles because all federal courts are intelligent. So it seems to me it's a question you can't answer. It's a question which asks, why should there be any jurisdictional rules? And you think there should be.
And Justice Scalia, honestly, I can't predict what would happen, but I would say that not all people who litigate about federal taxes are necessarily rational, and I think there would be a great...
I just don't want you to lose the second half of your argument. And we've spent all the time so far on jurisdiction, and I accept pretty much. I'm probably leaning in your favor on jurisdiction. But where I see the problem is in the second part, because the second part says restraining the assessment or collection of any tax. Now here, Congress has nowhere used the word tax. What it says is penalty. Moreover, this is not in the Internal Revenue Code, but for purposes of collection. And so why is this a tax? And I know you point to certain sentences that talk about taxes within the code.
Right.
And this is not attached to a tax. It is attached to a health care requirement.
Right.
So why does it fall within that word?
Well, the first point is our initial submission is you don't have to determine that this is a tax in order to find that the Anti-Injunction Act applies, because Congress very specifically said that it shall be assessed and collected in the same manner as a tax, even if it's a tax penalty and not a tax. So that's one
But
argument.
that doesn't mean the AIA applies. I mean, and then they provide some exceptions. But that doesn't mean the AIA applies. It says in the same manner as. It is then attached to Chapter 68 when it references that as being the manner of. Well, that it's being applied, or if it's being collected in the same manner as a tax, doesn't automatically make it a tax, particularly since the reasons for the AIA are to prevent interference with revenue sources. And here, an advance attack on this does not interfere with the collection of revenues. I mean, you've read the arguments, as have I. But I'd like to know what you say succinctly in response to those arguments.
So specifically on the argument that it is actually a tax, even setting aside the point that it should be assessed and collected in the same manner as a tax. The Anti-Injunction Act uses the term tax. It doesn't define it. Somewhat to my surprise, tax is not defined anywhere in the Internal Revenue Code. In about the time that Congress passed the Anti-Injunction Act, tax had a very broad definition. It's broad enough to include this exaction, which is codified in the Internal Revenue Code. It's part of the taxpayer's annual income tax return. The amount of the liability and whether you owe the liability is based in part on your income. It's assessed and collected by the IRS.
There's at least some doubt about it, Mr. Long, for the reasons that Justice Breyer said. And I thought that we had a principle that ousters of jurisdiction are narrowly construed. That unless it's clear, courts are not deprived of jurisdiction. And I find it hard to think that this is clear, whatever else it is. It's easy to think that it's not clear.
Well, I mean, the Anti-Injunction Act applies not only to every tax in the code, but as far as I can tell, to every tax penalty in the code.
But, Mr. Long, you said before, and I think you were quite right, that the Tax Injunction Act is modeled on the Anti-Injunction Act. And under the Tax Injunction Act, what can't be enjoined is an assessment for the purpose of raising revenue. The Tax Injunction Act does not apply to penalties that are designed to induce compliance with a law rather than to raise revenue. And this is not a revenue-raising measure because if it's successful, nobody will pay the penalty, and there will be no revenue to raise.
Well, in Bob Jones, the court said that they had gotten out of the business of trying to determine whether an exaction is primarily revenue-raising or primarily regulatory. And this one certainly is expected to raise very substantial amounts of revenues, at least $4 billion a year by the...
But Bob Jones involved a statute where it denominated the exaction as a tax. Here we have one where the Congress is not denominating it as a tax, it's denominating it as a penalty.
That's absolutely right, and that's obviously why, if it were called a tax, there'd be absolutely no question that the Anti-Injunction Act applies.
But even the section of the code that you referred to previously, the one following 7421, the AIA, it does very clearly make a difference, 7422, make a difference between tax and penalties. Very explicit.
Yes, it does. That is correct. And there are many other places in the code where
the best collection I found in your favor, I think, is in Mortimer Kaplan's brief on page 16, 17. He has a whole list, all right? So I got my law clerk to look all those up. And it seems to me that they all fall into the categories of either, one, these are penalties that were penalties assessed for not paying taxes. Or two, they involve matters that were called by the court taxes. Or three, in some instances, they were deemed by the code to be taxes. Now, what we have here is something that's in a different statute that doesn't use the word tax once, except for a collection device, and in fact, in addition, the underlying AIA reason, which is to say to the Solicitor General, we don't care what you think. We in Congress don't want you in court where the revenue of a state, Tax Injunction Act, or the revenue of the federal government is at stake. And therefore, you can't waive it. Now, I got that. Here it's not at stake. And here there are all the differences I just mentioned. So I ask that because I want to hear your response.
Well, there are penalties in the Internal Revenue Code that you really couldn't say are related in any close way to some other tax provision. There's a penalty that's discussed in the briefs for selling diesel fuel that doesn't comply with EPA's regulations. So there are all kinds of penalties in the code, and I think
Mr. Long, aren't there places in this Act, fees and penalties that were specifically put under the Anti-Injunction Act? There's one on health care plans, there's one on pharmaceutical manufacturers, where Congress specifically said the Anti-Injunction Act is triggered for those. It does not say that here. Wouldn't that suggest that Congress meant for a different result to obtain?
Well, Congress didn't use the language, the Anti-Injunction Act shall apply.
No, but in Section 9008 and in Section 9010, it specifically referred to the part of the code where the Anti-Injunction Act is.
All of Subtitle F, which picks up lots of administration and procedure provisions, but those are fees, and they're not. Congress did not provide, in the sections themselves that they should be paid as part of a tax return. So they were freestanding fees, and by using that Subtitle F language, Congress plugged in a whole set of rules for how to collect and administer the fees, and it went not just to assessment and collection, and the IRS has recognized this, but to examination, privacy, a whole series of additional things. So I think it would be a mistake to look at that language and say, oh, here's Congress saying they want the Anti-Injunction Act to apply. They're actually doing more than that. And yes, I grant you could look at Section 5000A, the individual coverage requirement, and say, well, they could have been clearer about saying the Anti-Injunction Act applied, and that's certainly true. But again, they were trying to accomplish a lot. It's
easier to talk about this case if we just forget the words "for the purpose of restraining assessment or collection." In a sense, that brings the jurisdictional question and Justice Breyer's question together. It seems to me, maybe you could just comment on that language. Is that sort of language usually contained in a jurisdictional provision? You often don't know the purpose of a suit until after the thing is underway. I can see it with malicious prosecution and some civil rights. Does it strike you as somewhat unusual to have this provision in a jurisdictional?
It does strike me, honestly, as a bit unusual, but this is an old statute. The core language is essentially unchanged since 1867, and I think that's part of the explanation for it. And again, it's become the center of a series of provisions that very carefully control the circumstances in which litigation about federal taxes can take place.